United States.
Thank you, Chair. Thank you, Chair. The United States provides its support for the statement of Group B. With regard to the protection of broadcasting organizations in the digital age, the United States continues to support updating such protection under the terms of the 2006-2007 WIPO General Assembly mandate, which calls for a signal-based approach to provide protection for the activities of broadcasting organizations in the traditional sense. However, the text of the current draft, text on broadcasting organizations, in our view, exceeds the General Assembly mandate with its inclusion of new exclusive rights of fixation and transmission of stored programs. The United States believes that to remain consistent with this mandate, the scope of rights to be granted should be limited to providing traditional broadcasting organizations with a single exclusive right to authorize simultaneous retransmissions to the public of their linear broadcast signals. We feel that this single right approach is the most prudent manner to address the core problem of signal piracy, while still being able to achieve consensus at the international level. Of course, each jurisdiction would remain free to provide additional, more specific rights in their national laws as they see fit. The United States is not alone in our concerns, as significant questions and concerns were raised at SCCR 45 by a variety of member states and regional groups regarding the treaty's objectives, rights to be granted, and scope of protection. While it is clear to us that much work remains on improving and focusing the text, the United States continues to support that work. We look forward to constructively engaging in the continued work of improving the text at the next SCCR. Regarding exceptions and limitations, the United States believes the current international framework for copyright exceptions and limitations provides sufficient flexibility, which is consistent with well-established international standards for countries to adopt exceptions and limitations to advance their own national, social, cultural, and economic policies. The United States believes that an informed discussion of exceptions and limitations within the SCCR can be useful to member states who are interested in tailoring exceptions and limitations to their own needs and circumstances. For example, such an informed discussion could facilitate the development of high-level principles and objectives or best practices to assist member states to craft and improve national copyright exceptions and limitations for libraries, archives, museums, and educational and research institutions, as well as exceptions for persons with disabilities. Finally, regarding the other matters topic, copyright in the digital environment, and its particular focus on remuneration rights in digital music and audiovisual streaming industry, the United States has consistently expressed our view that the SCCR is not the proper forum to address marketplace or contractual issues or to resolve matters relating to the relative bargaining power between private parties and competition-related considerations that may exist in the creative ecosystem. Thank you, Chair.